Professor Tribe, I want to begin quickly with where the court began today, which is on the question of jurisdiction. Do they even have the current jurisdiction to hear this appeal now, or must they send it back to the trial court immediately and allow this to be appealed, if at all, after the case is over? Judge Pan said there is strong precedent in the Midland asphalt case. She called it strong precedent that they don't have current jurisdiction. What did you make of that jurisdictional argument?
I think that in the end, the court is likely to avoid bouncing the case back and forth on that basis, because even though Judge Pan is certainly right, and this is not the kind of issue that necessarily was before the court at the proper stage right now, there is also strong precedent saying that a court in this circumstance can decide the merits when it's as obvious as it is here, and do that in a hypothetical way. That is, it can say, we may not have jurisdiction, but in order to prevent this from simply causing undue delay, we will assume we have jurisdiction, explain what we would do then, which is obviously to affirm Judge Chutkan's rejection of this ridiculous theory of absolute immunity unless you are impeached first, and then proceed. So although I think that wrinkle is a possible source of complication, I don't expect that it will delay things very much.
Sometimes you can listen to an appeals court hearing, a Supreme Court hearing, and just leave with no idea which way the judges are leaning on this one. I have a feeling that you have a feeling about where the judges are leaning on this one.
Yeah, it's more than a feeling. It would be absolutely astonishing if any panel of judges, let alone a panel as qualified and smart as this one, were to give the Trump argument the time of day. It's a ridiculous argument. It's not an argument that any real lawyer would have come up with. This idea of turning the impeachment judgment clause into a kind of magic wand makes no sense. I think it might have made sense to Donald Trump. Maybe he was the audience of one for the fast-talking John Sawyer in this case, because he obviously was pleased by the idea that since he got away with not being convicted in the second impeachment trial, and got away with it because he committed his most serious crimes right at the very end of his presidency, so that they could say that it's too late to convict you now, he could basically turn around and say, gotcha, because I engaged in these insurrection offenses at the very end of my presidency and you couldn't catch me in time, I will have my lawyer say in the impeachment trial that you can prosecute me later. And then when you try to prosecute me later, I'll say, well, change my mind. You can never get me. It's insane. And it's quite clear that the lawyer was saying what Donald Trump wanted to hear, but it's not going to work with this court or any court.
Is it conceivable to you that this court could rule, as it sounds like they would, in support of Judge Chutkan's denial of this invented immunity that it doesn't exist in writing anywhere, and that the Supreme Court could look at a ruling by this three-judge panel, a unanimous ruling possibly from this three-judge panel, and say, that's it, the case is done, we're not taking it?
Entirely possible. There's no good reason for them to take it. There might be close, difficult cases. The lawyer for the special counsel's office came up with a hypothetical in which perhaps a drone strike would have to be ordered by a president in very difficult circumstances where whether it's criminal or not is unclear. And in that very limited circumstance where a president has to make an instantaneous decision in the national security, there might be some kind of immunity. But nothing about this case is close in that way. And therefore, it's quite possible that the Supreme Court would say, we don't want to use a slam dunk case like this in order to explore a whole bunch of hypotheticals. This case is slam dunk for the reasons that you've already explored, but even more extremely, if it really were the case that you have to be impeached and convicted first, and if it looked like a president faced conviction, he could get SEAL Team 6 to kill the senators who would vote to convict him and make it impossible to be convicted. No civilized society can work that way. So what this argument does is it shows us in vivid color what Donald Trump means when he says he intends to terminate the Constitution. If we had a Constitution that allowed any president to commit crimes as long as he does so using the powers of his office, and then either because he resigns or because he does it too late to be impeached or too late to be convicted or contrives not to be convicted, he can get away scot-free. He is master of the universe. All of us are his subjects, not citizens. That's not the way the system works. And what we saw today was a glaring and terrifying demonstration of the kind of legal regime that Donald Trump says he believes our country lives under. It's simply not a possibility.